Thank you very much, Mary. Distinguished ministers and dignitaries, colleagues and friends, in my presentation today, I'll be addressing the UN Principles and Guidelines on access to legal aid in criminal justice systems. However, I'll be framing my remarks in reference to the qualified right to free legal assistance for every person charged with a criminal offense that's provided for by the International Covenant on Civil and Political Rights. I'll start by observing that the UN Principles and Guidelines are a new and non-binding international instrument adopted by states at the General Assembly in 2012. The International Covenant on Civil and Political Rights, on the other hand, is a United Nations Human Rights Treaty which entered into force in 1976, and its provisions are binding in international law on those states that have freely chosen to ratify it. The convention is widely ratified, and to date 168 countries have ratified the covenant. The two international instruments complement each other in a number of respects, and it's to the relationship between these two international instruments that I'm going to explore in my presentation this morning. I want to start first with the International Covenant. The precise wording in Article 14 of the Covenant reads in pertinent part, "In the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees in full equality: to be tried in his presence, to defend himself in person or through legal assistance of his own choosing, to be informed if he does not have legal assistance of this right, to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it." So to summarize, the qualified right to legal aid contained in Article 14 of the Covenant has the following 5 features. It's applicable only to criminal proceedings. It uses the more general term legal assistance rather than legal aid, although this does not appear to affect the substance of the right. The right is available to everyone in full equality. The state has the obligation to inform the accused of his or her right to legal assistance, and the right to assignment of legal assistance without payment is applicable only where the interests of justice so require. You'll have to bear with me, I have a slight cold. Now, it's this key phrase, "where the interests of justice so require," that I want to explore because of the central importance of this concept. However, first I'd like to explain what is the Human Rights Committee. The committee is a body of independent experts that monitors the implementation of the covenant. It has the power to hear what are called individual communications concerning the interpretation of the covenant. It is effectively a type of appeal from individuals and states that have accepted the individual complaints procedure. Normally, individuals submitting individual communications must first exhaust domestic judicial remedies. Decisions of the committee are not binding in international law. However, there's an expectation that these decisions will be followed by states. Now, the first communication I'll refer to is a 1983 case involving Norway. In this case, in this communication, the Human Rights Committee found that fines for 2 traffic violations did not meet the test of where the interests of justice so require, and therefore found that the state was not required to provide free legal assistance to the petitioner. Similarly, in a trespass case involving Australia in 1998, where the only sanction was a fine, the committee also found that the test was not met. However, in contrast, in a series of cases involving the death penalty, in states as diverse as Tajikistan, Ukraine, and Trinidad and Tobago, the committee held that it was axiomatic that free legal assistance should be made available to the accused at all stages of the proceeding. In another individual communication considered by the committee, involving this time Jamaica, it was also held that legal aid must be provided in proceedings before a constitutional court where the purpose of the case was to review whether a criminal trial that had resulted in the imposition of the death penalty was fair. So to summarize, the only guidance available from the Human Rights Committee concerning the meaning of the phrase, where the interests of justice so require, is it is not applicable in traffic and trespass cases involving fines only, and that it's clearly applicable in death penalty cases. However, since there's an extremely wide range of criminal offenses between death penalty cases and minor offenses involving fines only, state and regional courts have been historically left on their own to determine what types of criminal offenses between these two extremes meet the test of where the interests of justice so require. Perhaps one of the most important contributions of the UN principles and guidelines was to effectively provide this guidance to states as to what this phrase means. The UN principles and guidelines state that legal aid should be applicable in any criminal case in which an accused risks any term of imprisonment. The norm reflects standards that have been articulated at both national and regional level. For example, the European Court of Human Rights articulated the standard in 1996 in a case called Benham versus the United Kingdom. At the national level, the United States Supreme Court adopted the same standard in 1972 in a case Argersinger versus Hamlin, when it decided that whenever there was any possible deprivation of liberty, the right to legal aid was applicable in all criminal state proceedings. Sorry. It's interesting to note there are some similarities between the Benham case decided by the European Court and the Argersinger case decided by the US Supreme Court. The Benham case involved a criminal offense that carried a possible term of prison of 3 months, and the accused was sentenced to 1 month in prison. The Argersinger case involved a possible prison sentence up to 6 months, and the accused was sentenced to 90 days of imprisonment. Hence, in both cases, the accused faced relatively short periods of potential confinement. Now I'd like to turn to another interesting development, which concerns at what stage of the proceedings legal aid should be provided. As I mentioned previously, the Human Rights Committee has concluded that legal aid should be provided at all stages of the proceedings in death penalty cases. The rationale advanced by the committee was that the failure to provide legal representation at all stages of the proceedings could affect the fairness of the proceedings as a whole. However, the committee has not clearly identified what is meant by the phrase, all stages of the proceedings. Although in an individual communication involving the death penalty, the committee found that the absence of free legal assistance at the first preliminary hearing before a judge constituted a violation of Article 14. The committee has also called for an accused to be granted prompt access to counsel. Nevertheless, there appears to be no decision by the committee that addresses the subject, or the situation rather, where a person is subject to interrogation by the police in the absence of legal counsel after arrest or detention and prior to the first judicial hearing. Again, the UN principles and guidelines provide an important contribution on this subject, potentially in interpreting the covenant. The principles and guidelines provide that when a person is arrested, detained, suspected of, or charged with a criminal offense, the person has a right to legal aid. The principles and guidelines also provide that at the time of the deprivation of liberty, and prior to any questioning of the person concerned, he or she is to be informed of their right to legal aid, their right to remain silent, as well as the potential adverse consequences of voluntarily waiving these rights. This standard, which is articulated in the UN principles and guidelines, follows the development of progressive standards at the national and regional level. For example, at the national level, the US Supreme Court determined in 1966 in Miranda versus Arizona that any person brought into police custody had to be told 4 things before being questioned. The person had to be told that they had the right to remain silent, that anything a person says can and will be used against him or her in a court of law. The person has a right to an attorney. Now, this right under Miranda includes the right to meet with an attorney prior to interrogation and for the attorney to be present throughout the interrogation. And the fourth Miranda warning is that if a person cannot afford an attorney, one will be appointed for him or her. In a related development, the European Court of Human Rights in 2008, in the case Saldus versus Turkey, found that to protect the right to fair trial as a rule, access to a lawyer should be provided as from the first interrogation of a suspect by the police. The European Court stated that the rights of the defense would in principle be irretrievably prejudiced when incriminating statements made during police interrogations without access to a lawyer were used to obtain a conviction. Similarly, the Inter-American Commission on Human Rights in 1986 said in its conclusions on El Salvador that the right to counsel applies from the first time a person is interrogated. Moderator, this concludes my presentation.